Hi, Step 6 Prepared Technology Negotiation. My name is Diana Caterina Osorio Patiño, Student Group, Brian Steven Colmenares Espinosa, Sandra Milena Gómez Núñez, I'm Charlie Viviana Duarte, Tutor, Juan Carlos Amezquita, Group, I'm 43. Definition of node to project the intellectual property of the software. Software intellectual property, also known software IP, is a computer core on program that is projected by law against copies thereof other sources that is not permitted by other owners. Software IP belongs to the company that either created or purchased the right to that core or software. Any authorized use of it by someone else is illegal. Intellectual property law recognizes four types of intellectual property that can be protected. When present takes like no, they apply to software intellectual property. The four types of intellectual property and one patents. Software patents are extremely valuable for vendors because they can protect aspects of the production that other intellectual property laws current. And different countries have different approbation to the property of software. Two copyrights. Software copyrights cover the specific code assets in the program or elements in the access interface. Copyright is automatically obtained by the creation in the original work. Unlike with parents, they do not need to go around an application process. Three, trade secrets. Trade secrets can be protected by law as long as the owner, market, and responsible effort to keep is a secret and no one else has discovered and independently. For trademark, and trademark is a symbol, tracks, note, or another type of expression to distinguish a particular product or brand. Name of brand or products are of aftermarket and trademark and trademark symbols. TM for indirect trademark and RED for registered ones. Value methods action to establish the price and the reason of the selection. For the evaluation in the software methods recommendation by Rayleigh and 19 and 19A will be applied. Cost methods, the cost saving approach for service and developed in the target basis. Due to one part that technology process have improved and after a study carried out, it was found that this company has generated havings in the research and developed cost of 18% compared to the competition taking the average cost of research and developed for analysis. Entry method, the software company Columbia CA and the royalty distribution agreement with and distributor of the products. In the following teams, 25% of the projected income for sales of the production corresponds to company software the Columbia C&A. 75% of those revenues correspond to the distribution open team. Expresses are estimated to represent 17% of projected revenue. Market values, the royalty calculation appropriate is sizing and it is from that after conduction of analysis of the licenses agreements in the other companies similar to company the Software Columbia CA. It was consulted that the royalty rate of the user of license in the right from 15% to 20% of projected revenue.
Hello, my name is Brian Colmenares, and I'll present the general condition of the licensing and the negotiation. Uh, Number one, parties. The register legal name and location of the parties, and in this case, is company the software Colombia S.A. And the following items are start date for the term of a development contract in the strict sense. The parties may establish a specific contract duration and specific start and end dates. And the following issues are duration. And the duration shall appear normally established within a determinate or indefinite duration. And in the latter case, it should be noted that licenses is granted for the totality of years that comprise the duration of the rights of exploitation of the software in accordance with the applicable intellectual property regulation. The following methods are natural or the licensed IP, grant only those patents that cover the specific product that the license wishes to access, application that allows the integration of financial and accounting data with a management system project based on the principle of scored card, balance, and ABC timing right. The following items are work schedule and to prepare a product for the market, and it's important to establish a clear and mutually agreed schedule of work before granting the license. The contract is concluded. Okay, the following items are costs. For Software Colombia S.A., the cost calculation we made based on the research and development cost saving approach. We represent a total research and development savings cost of 15% of projected revenues. The following items are the lump sum royalties. Normally, royalties are paid in addition to the license fee. They are based usually on a unit, a volume, or a weight of sale. The 25 rule approach is used frequently for the negotiation of the royalty. This necessitates an appreciation of the operating cost, the likely sales price, and the net margin for the product from the technology-based licensing. For Software Colombia S.A., the royalty rate for the use of license is between 15 and 20 the project revenue. And the following items are payment scheduling. Clause 1. Payment for all license and support fees shall be due 30 following receipt by licenses of an invoice by licensor specifying the amounts due, unless otherwise set forth in the ordering document accepted by licensor in writing. Clause 2. Fees are non-refundable. Clause 3. Licensor shall invoice license for the initial support fees upon the initial order of the licensed product. And the following items are license options, the development and exclusive license option agreement. Okay, agreement. Item 10. Option term on license. During this period, the buyer can keep the software for 6 months. The company can further evaluate its potential or raise capital for the product development without commitment. 11. Right of first refusal. If employer permanent closes to business. And 12. Scope or license. This non-disclosed license can here and license access here and many scope or license. 9. Uh, the following items are liability. In event shot, either party agreed liability except to greater or 3 times the first payable or to be paid by license under this agreement. And warranty on license patents and use is on resource or outsource or purchase any recourse for any part other than the licensor provision of technical service. Entered into any agreement or made any agreement or become liability to any third party. Ownership of IP. The company Software Colombia SE is the sole owner and retains a right, title, and interest, whether expressed or implied, over any industrial estate that the contractor does not have or acquire any right, title, or interest. And, ownership or improvement, add modification and alteration and improvements made or add the product by the bidder shall be considered the property of Software Colombia S.A., who shall remain the property of the bidder during the contract, and the bidder hereby agrees not to grant a security interest in such products to any part other than owner. The next, the colleague Sandra.
18. Infringement. The live session is the only exclusive award and has the sole exclusive right congratulation on the content letters platen, largely numbered in table name. When granted right is used sublimes to the third parties. Parties must make a number of critical decisions that must be taken account. 19. Termination. If the participant fails to perform an agreement obligation, regardless of the legal consequences, the company Software Colombia is legal entitled to determine or cancel the agreement without full legal formality if participant does no action when the amount received. Notification by receipt letter. 20. Choice of law. Close contract purposes. The purpose is a contract is the Porsche software for Company Colombia, which are the function of software purposes. The technical and specific condition is the software are defined in head of the agreement. Clause 2. Definition. The means attributed to the terminus with musical capitalized in the agreement be sums up. The singular and plural form on the file known and the use concepts which they are used. Other terms begin with a capital letter must be ended in line when the Federal Decree 15 on 2000 and well as the meeting providing the process document. There no state in the relevant case of this clause should be interpreted in the natural and evident context. Clause 3. Maintenance on lines in the established days, the contractor agrees conduct lines maintenance. Clause 4. Obligation of the contracting party exercise directing on direction, sublime and the control over the contract. 420 pay for service by according to the third 14 disagreement. Clause 5. The contract parties rights. 5.1. Makers use the contract session terms. 5.2 Point of use clause the course in the French, the penal clause on any other legal or contractual right conferred on the contracting entity. Clauses. A county complies with the objects for the same clause 1 and the agreements it is responsibly copied the software Colombia in the action of the contract goals. Company de Software Colombia I see we will validate Damon's clause in the employees and on console, as well as the workers and on console in the subcontractors. Clause 7. Termination. Modification and unilateral interpretation contract unilaterally terminate. Modifying trading contract. In accordance with Article 15 to 70 Live 19 of 1993, when it wins in the necessary contract to comply with object disagreement. Clause A. Finishing the contracted flight to comply with contractual obligation arise from this contract. The legal procedure be before annexation levels. 21. Dispute resolution. Any disputes, controversy, and claim the rise or pertain to the disagreement, or the interpretation, breach, termination, or validity thereof, should be brought to consulting among the parties involved. Such consult shall begin within 7 days after the one party and center with requirement for consulting of the parties involved. If the use cannot be wrought with 35 days after start of shall consultation, the dispute will submit arbitration at the request any of the party, which is not the person or the party. One conclusion per student explains the importance of the preparing both negotiation and technology to achieve better results. Brian Colmenares. It's very important to prepare for negotiation of technology to be able to identify expectations about technology. They have analyzed in the interest of consumers to collect and organize information about the market and to be clear the terms for the contraction is significantly more important than the price. And to capture the trends, these are very important because it is only the master the percentage of profits we can have in now technology with betray protection. Diana Caterina, Technology-based evaluation is tangible as it becomes more common as more companies now focus on manufacturing technology products or proving technology servers. In other words, basic research, application, and technology development have produced this result, and it stands to create intelligent property provision base to share results. The coordination to reset results between those involved to develop products must be compliant and license agreement. Once the porting intellectual property received is determined, the ways to use special proponents in the intellectual property and the special intellectual property also agreed upon. Sandra Milena Gomez. This is significant because it allows the both participation organization and the negotiation to benefit from the other servers and products. As receivable, everyone notices that the expectations were met, and the process will take place and relax and friendly environment. In addition to organization day, there will test member inequalities to proportion and will evaluate the use work system that they will accept purpose in common. Knowing the entities is the other part because knowing what to expect, how and when will be strong beneficial. Omar Alfredo Marin. We can conclude that the transference is a legal and established negotiation. To practice, the term of the negotiation with Apple and the block consider aspects of the contract proposals. In previous jobs, I have adopted concepts, process, performance, build important documents such and chapters to market developed software compañía Software Colombia and similar methods good bad. Negotiation cloud is soft of fairly. Importance of preparation negotiation to a technology that is in each process. It based on communication servers are met between two one or mass party exchange proportion finally. Therefore, it's well important to see information on how the technology and organization of the other party in the negotiation. What happened before you need to work the what economic bit negotiation embarked between the benefit of the both parties. No account negotiation will start suffic compete collaborative integrate on the decentralized.